Rolling out new tech like AI profiling without checking privacy risks first? That could trigger massive fines, but a GDPR data protection impact assessment spots danger early and keeps you safe. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. If you would like personalized guidance, you can contact our team or other qualified professionals. Hey everyone, Robert here, legal consultant, licensed tax advisor and founder of Chiroptera Consulting based in beautiful Slovenia. We've guided many companies through DPIAs for high-risk projects, helping them launch innovatively without GDPR headaches. Today, we're explaining data protection impact assessments, when they're mandatory and how to conduct one effectively. Picture this. New technologies promise efficiency, but mishandle personal data, and harm follows. DPIA is your pre-launch risk scanner, mandated by Article 35. Let's break it down step by step. First, the basics and responsibility. A data protection impact assessment, or DPIA for short, is a structured process to identify and minimize privacy risks before high-risk processing starts. Personal data means anything identifying someone, like names, health information, or location. The data controller, the entity deciding why and how data is processed, bears primary duty to conduct it. Processors assist by providing relevant information. Before starting any high-risk processing, consult a qualified professional regarding your obligations. Here are some practical tips to get you started. Firstly, involve cross-functional teams. Secondly, get input from processors. And thirdly, document decisions thoroughly. Next up, what counts as high-risk processing? DPIA is mandatory when processing likely risks individuals' rights, like privacy or non-discrimination. Key triggers from Article 35 and European Data Protection Board or EDPB guidelines follow. Firstly, if you plan to conduct automated decisions with legal effects like AI loan approvals. Secondly, any large-scale processing of sensitive data like health, biometrics, ethnicity, and similar. Thirdly, if you plan to conduct systematic large-scale monitoring of public areas like facial recognition CCTV. Simplified, if you use innovative tech like AI processing, profiling, and vulnerable groups, or combination of those, you probably need a DPIA. If you are on the verge, check national authority lists and consult our team or another qualified professional for specifics. Now let's take a look at what to include in the data protection impact assessment. Your DPIA must systematically cover description of processing, purposes, and legitimate interests, assessment of necessity and proportionality, risks to individuals' rights and freedoms, planned measures to address risks like encryption, minimization, and safeguards, seek data subjects' views where appropriate, embed outcomes into your project for privacy by design. This turns risks into managed safeguards. To comply with this, it is essential to be aware of the timing and mandatoriness of the DPIA. We cannot stress this enough. Conduct DPIA before processing begins, early in planning. DPIA is mandatory for high-risk personal data processing types we covered. Once you conduct the initial DPIA, you're not off the hook yet. You have to reassess your DPIA if risks change or every few years. If residual high risks remain after mitigation, consult our team or another qualified professional and your supervisory authority. Exemptions when you do not need a DPIA are rare. For example, for similar low-risk operations with prior assessments and processing that has to be done on the legal basis of legal obligations, Article 6, Paragraph 1c, or public tasks, Article 6, Paragraph 1e. Err on the side of caution for compliance. To recap, controllers lead DPIAs for high-risk activities like large-scale sensitive processing or automated decisions. Include description, necessity check, risks, and mitigations. Do it early. Skipping invites fines up to 2% of global turnover, plus reputational damage. But when done right, you can launch your groundbreaking AI company confidently, build trust, and embody ethical data practices. DPIAs aren't burdens. They're smart risk management, turning potential pitfalls into strengths. If this helped your next project, like the video, share it, and subscribe for more GDPR insights. Check our Knowledge Center for more similar content. The link is below. Thanks for watching, everyone, and remember, compliance with the law prevents the flaw. Till next time.